Well, welcome to Landmark Chambers webinar, Bill of Rights webinar series session 3. We are delighted to see so many of you joining the session today and hope that you will find the presentations and discussion to be useful and informative. Please note, as I'm sure many of you already know, that this is the last of a 3-session webinar series. The recordings and presentations for sessions 1 and 2 can be found via the resources page in our website, where you will also find the presentations and recording for this session in due course. My name is Richard Drabble, Queen's Counsel, and I will chair the session today, joined by my colleagues Luke Wilcox, Miranda, Butler, and Katharine Elliot, who I will formally introduce with a few words in a moment. I need to begin with a few housekeeping points. First, your microphones are automatically muted, so you will not need to adjust your local settings. Second, we very much welcome questions throughout the session. Please submit them via text in the Q&A section, which may be found at the top or bottom of your screen. If you would like to remain anonymous when asking a question, please make sure you tick the Send Anonymously box before submitting your question. We will endeavour to answer as many questions as possible at the end of the presentations. As I have already said, this webinar will be recorded. You will receive a link to the presentation and the recording shortly, you will receive a link to the presentation and the recording shortly after the event concludes. Finally, if your connection is lost at any point during the webinar, we invite you to rejoin the meeting by clicking on the original link once again. That's the housekeeping. I have 2 related points I want to make as chair before I formally introduce the speakers and hand over to the first of them. The preliminary point I want to make is that you may all have noticed that there has been some political developments in the last few days. The received wisdom that I am getting from sources like the Bar Council and who must be in conversation with the MOJ is that the second reading of the bill is unlikely to take place before the summer recess, and therefore before the autumn. This must place a question mark about whether the shape of the bill, when it reaches second reading, will be as it presently stands. The bill is very much a creature of the present Lord Chancellor's work, Dominic Raab. It's markedly different from the results of the review that was carried out under the auspices of his predecessor. And it's a matter of speculation on which you may have your own views as to how likely it is that Dominic Raab survives. I don't mean that in a pejorative sense, but is still in the same post in government come the autumn under a new Prime Minister. So we shall have to wait and see. That creates an amount of uncertainty over what we are about to discuss. The second point that I would want to make is that the topics that we are discussing today differ in their susceptibility to the sort of change that may follow from any political change in the holder of the office of Lord Chancellor. The topics to do with overseas military operations and freedom of speech and expression may be relatively invulnerable to change. There probably is a fairly widespread consensus in the Conservative Party behind those measures. The topic of deportation and the tests to be applied in reconciling deportation with Article 8 in particular are, one suspects, rather more vulnerable to change. Not at all clear that there is the same consensus behind the way in which those provisions are expressed. One mental exercise that you might usefully want to carry out when Miranda talks is to envisage the sort of mental processes that the court is being asked to go through and how those will be reconciled with Strasbourg case law once we're a few years into the operation of the bill, should the bill get to fruition in its present form. That's all I wish to say by way of the Chairman's remarks. I now want to introduce the speakers and hand over to Miranda, who is the first. So doing that, Miranda Butler, who will speak first on deportation, specializes in immigration, community care and public law. She has lots of experience in claims relating to unlawful detention, prisoners' rights, trafficking and detention support. And a very recent endeavor has been her work as co-founder of the Ukraine Advice Project, which started in February 2022. Luke Wilcox will be talking about overseas military operations. Luke has a broad practice across the landmark areas of property, planning, and public law. The public law work includes a particular interest in business rates and regular advice to ombudsmen. He is also a member of the C panel and has been a policy advisor before he went to the bar to the Constitution Committee of the House of Lords. Finally, by way of introduction, Katharine Elliot will talk on freedom of expression and journalistic sources. She joined Landmark in April 2022 and continues to grow her public law practice in all areas, and in particular in the Court of Protection, Health and Social Care and Education work. She is also a member of the C panel, and relevant notable cases include Kent County Council against P, which turned on the balancing exercise of balancing protected persons' rights under Article 8 with those of the press under Article 10. So with that by way of introduction, can I hand over to Miranda to talk about deportation?
Thank you very much for that kind of introduction, Richard, and thank you everybody for joining us today. As Richard's already outlined, I'm going to be talking about the fascinating and challenging provisions in the Bill of Rights Bill regarding deportation. There are two key provisions I'm going to be talking about. One is Clause 8, which helpfully for those of us trying to memorise this lengthy bill refers to Article 8 and introduces a new standard for the review of deportation legislation. The other clause I'm going to be talking about is Clause 20, which concerns individual challenges to deportation orders on the basis of Article 6. I am sure that I do not need to tell those attending here that these changes arise out of long-standing government concerns about the use of human rights claims in the context of deportation orders and successive legislative attempts to narrow and one might even say straitjacket the circumstances in which courts and tribunals are allowed to allow those claims, especially in cases of more serious offending. Immigration practitioners in this webinar will no doubt be aware of the changes to the immigration rules in 2012, and in particular, the changes brought into both deportation and non-deportation Article 8 cases by the 2014 Immigration Act, which I'm going to touch on briefly. The summary conclusion that I've flagged up here on my first slide is quite simply that it is hard, if not impossible, to see how these provisions are compatible with the ECHR and the ECHR jurisprudence. So looking at the reason behind these changes, beyond the long-standing concerns that are articulated in certain parts of the media and certain parts, large parts of government indeed, about deportation, These changes may be influenced by the modest increase in human rights appeals that succeed in the deportation context. Here are some statistics from the Independent Chief Inspector of Borders and Immigration's 2021 report about Home Office presenting officers. And what you can see here is a gentle upward trend from October 2018. And many commentators have suggested that the reason for that upward trend was the interpretation given to those provisions in the 2014 Act, to which I just alluded, by the Supreme Court in KO, Nigeria. So very briefly, the 2014 Act introduced new standards for the court to apply when they were considering whether it would breach a child and a potential deportee's Article 8 rights to family life as a result of the deportee's removal from the UK. In the context of deportation, the relevant standard was whether the separation or the impact of the deportation would be unduly harsh. And in the context of non-criminal cases, the question was whether it would be reasonable to expect a child to leave the UK. One of the core issues in that case was whether, in applying those thresholds, the court would be required to balance a child's interest against the degree of public interest in removing the parent, and to balance it against the weight to be given to the harm and opprobrium associated with that offending. The court rejected that suggestion and rejected the suggestion that in the deportation context, one would need to show very compelling reasons to succeed. So whilst the individual cases were unsuccessful in KO, Nigeria, the Supreme Court did, in its interpretation of the Act, potentially liberalise it, possibly beyond what the government had originally hoped. And so it is against that backdrop that we come to Clause 8 of the bill. Importantly, and there's been some slightly incorrect commentary on this does not purport to introduce a new test for individual challenges at this stage. Clause 8 refers exclusively to challenges to deportation legislation. So we are not considering a prospective individual coming to court and saying, my rights and my family's rights will be breached by my deportation. We are considering a challenge where somebody, either concerning primary or secondary legislation, says these legislative provisions are incompatible with Article 8. In considering such a challenge, the provision provides that the court cannot find an Article 8 breach unless the legislative provisions in question would lead to manifest harm so extreme that it would override the otherwise paramount interest in removal. And just in case any of us thought that that test could be watered down somewhat, extreme is defined in clauses 3 to 4 as exceptional and overwhelming harm, which cannot be significantly mitigated or which is irreversible. And it further adds, just to put a cherry on top of this particular sundae, that an applicant will only win in the most compelling circumstances, even where those that very high threshold is met. I've already set out that this provision concerns deportation legislation, not individual claims. I'm going to come on to talk about the significance of that in a minute. But just looking at the language here, it is worth noting that the provision covers all foreign criminals. And whilst it refers in an undifferentiated fashion to Article 8, which of course protects both private and family life, the test itself only considers the situation of essentially a family life claim. And it applies in a restrictive and narrow way only to certain qualifying family members. So any human rights practitioner here will be very well aware of the fact that Strasbourg has taken a contextual and generous approach to interpreting and applying the concept of family life, extending it in appropriate cases to adult children, spouses, dependents, and non-biological relatives. Here, qualifying family members only include minor children with whom the potential deportee has always had and continues to have a genuine and sufficient relationship, and that child must be either British or to have lived in the UK for at least 7 years. You will immediately see that that is a much narrower text than the one that currently exists in legislation and in case law. The only other qualifying family member is a dependent who is either British or settled. So it excludes a very large number of potential family members who would plainly enjoy family life under current case law. It's also evident that whilst, as I mentioned, purporting to cover family and private life in its entirety, the only categories in which an individual can succeed in a challenge to deportation legislation is on family life grounds. So it is envisaged that no private life claim could succeed. It's, of course, exceptionally difficult to succeed in a private life claim at present, but in any event, this provision seeks to decimate such a claim. So what does this mean? What's going on here? Why aren't we just introducing a test of manifest harm in individual changes? The bill doesn't propose to repeal any of the pre-existing deportation legislation, including the legislation that I referred to as having been interpreted perhaps against the government's wishes in Nigeria. However, the announcements that have come with the bill have made clear that the government intends to use this bill to introduce much, much more restrictive legislation. So we should anticipate that were Clause 8 to come into law, it would be followed by the Immigration Act 2023, which would incorporate and apply the manifest harm test. And then, of course, any challenge to the manifest harm test would likely fail on Article 8 grounds under Clause 8. And therefore, the Putative Immigration Act 2023 would make it impossible, or practically impossible, for individual applicants to succeed in human rights claims unless they could meet this, what I've referred to here as an insuperable hurdle. I find it extremely hard to envisage any case, even one involving a relevant qualifying family member, that would meet this, frankly, hyperbolic test of extreme, exceptional, overwhelming, and manifest harm that arises in the most compelling circumstances. Such a claim would almost inevitably amount to an Article 3 claim, or perhaps arise under other articles such as Article 2 or Article 4. And therefore, I've suggested on this slide that this legislation could be used simply to prevent Article 8 claims succeeding in deportation cases. My final point I wanted to make on Clause 8 is, well, where does Strasbourg come into this? And that's perhaps a question that runs through the entirety of this bill. Strasbourg has been willing to take a comparatively light touch in deportation cases. In cases indeed, it recognised that contracting states should have a wide margin of appreciation in deportation cases. And they also emphasised that the Strasbourg court would show deference to domestic tribunals unless there were strong reasons for it to interfere. And in the case of Untitled, the court considered domestic legislation, including the 2014 Act that I've been referring to, and they found that the current plethora of domestic deportation legislation allowed domestic judges to conduct a full proportionality assessment, looking at all relevant criteria as articulated by the Strasbourg court, for instance, in cases like Nuna or Maslov, and therefore was lawful. But it also, at least implicitly, recognised that insofar as domestic legislation purported to restrict or remove that ability to undertake full proportionality assessment, that would be unlawful in breach of Article 8. So quite simply, I cannot see how the Strasbourg court, applying those principles, could endorse legislation that, for the reasons I've set out, seems to decimate any meaningful Article 8 assessment, both under a proportionality assessment and also simply under questions of whether Article 8 is even engaged by throwing out private life and throwing out large parts of family life. Therefore, this clause is likely to put the UK on an immediate collision course with Strasbourg. And were the Immigration Act 2023 to be passed in form that I've suggested, and were individual decisions to be made under it, we would likely see in very short order a number of urgent applications to the Strasbourg Court and much litigation at the international level, which was, of course, one of the many reasons why the Human Rights Act was brought in the first place, in order to, quote, bring rights home and enable domestic judges to deal with those cases at a more proportionate cost. I'm now going to talk about Clause 20. Clause 20 is perhaps a little less radical in what it purports to do, and I'd be very interested if any of the attendees have more insights than I've been able to glean into what the government is really intending to do with this provision. So Clause 20 applies to challenges to individual deportation orders. We're not in the business of challenging legislation here. We're looking at individual applicants who are seeking to resist their deportation on the grounds of Article 6. And it says that there will be no Article 6 breach in a deportation case unless the deportation is carried out would interfere with the right to a fair trial so fundamentally that it would amount to a nullification of that right. It also has what you could refer to as a sort of soft quasi-outer clause regarding assurances. Many people who've worked on deportation cases will be used to government assurances. I, for instance, once represented a quite serious offender who was liable to be deported to Somalia, had serious health conditions, and the Home Office contacted the Somalian authorities and obtained assurances about the health provision that would be made for my client if he were removed there. At present, those assurances can be considered under a freestanding assessment by the court or tribunal. However, this clause provides that a court must treat the Home Office's assessment of assurances as correct and determinative of the appeal, and must dismiss the appeal on the basis of those assurances, subject only to a rationality threshold, so subject only to circumstances in which the court or tribunal considers that Secretary of State has interpreted those assurances unreasonably. This is where we come into my slight confusion about the need for this clause. In my practice and in the case law, Article 6 does not arise very frequently. Even in fairness cases, it's often not the provision that's relied on. So in the case of Chari and Bindlos, I'm sure you all will be familiar with, that concerned the so-called deport first, appeal later provisions. The court found in the individual's favour applying the procedural element of Article 8 rather than Article 6. Similarly, the clause provides that there will not be an Article 6 breach unless the right to a fair trial would be nullified. That term isn't defined in the legislation, but looking at Strasbourg case law, it's slightly hard to see how a claim that would succeed under Article 6 wouldn't also meet a nullification threshold. So in cases such as Stanev in Bulgaria, the court has acknowledged that Article 6 isn't an absolute right, and so some restrictions on the right of access to the court or access to justice may be permitted. However, they must not restrict or reduce access to a court so that the very essence of a right is impaired. I cannot envisage a scenario in which the very essence of the right to a fair trial is impaired, but it is not nullified. It strikes me that this criterion would almost always be reached in the case where Article 6 would win in any event. Furthermore, the court is willing and able simply to rely on the common law right of access to justice, and it has done so repeatedly in finding against the Home Office on fairness grounds. Two fairly recent significant cases are the first medical justice case in 2010, including concerning no notice removals, and the FD Afghanistan case that concerned removal windows. And in both those cases, the court was perfectly happy to find unfairness through essentially the lack of notice, the lack of ability to challenge removal decisions, on the basis simply that it interfered with the common law right of access to courts and access to justice. That principle, of course, applies via the principle of legality, which requires that in the case of fundamental constitutional rights, they can only be removed through express statutory wording. I do not see any express statutory wording in these provisions that would out the principle of legality and that would prevent courts simply applying the common law right of access to justice, even if they were unable to find in an applicant's favour under Article 6. Therefore, to sum up, whilst Clause 8 seems likely to create significant issues, both domestically and internationally, with its departure from settled principles of Article 8, I struggle to see what difference Clause 20 is likely to make in deportation cases. Thank you very much for listening. I'm going to pass it on to Katharine now.
Thank you very much, Miranda. Hello, everyone. As Rich mentioned at the start, I'm going to be talking about freedom of expression, or rather changes in relation to Article 10, because we'll see that the focus of this bill is rather narrower onto freedom of speech, and then looking at journalistic sources. So effectively, what this bill is seeking to do is to put freedom of speech at the front and centre of the Bill of Rights. It states in Clause 4, so very high up in the order of clauses, that when determining a question which has arisen in connection with the right to freedom of speech, the court must give great weight to the importance of protecting the right. So that's Clause 4.1. You'll see it's right to freedom of speech, not right to freedom of expression. And it's made clear what this means in Clause 4.2, that freedom of speech means Article 10, so far as it consists of a right to impart ideas, opinions, or information by means of speech, writing, or images. Because you'll recall that Article 10 includes the right to hold opinions and receive information. So freedom of speech is defined in this bill to only include imparting, and it is that which is going to be protected via Clause 4.1, and to which great weight must be given by the courts. This is a very deliberately distinguished subcategory, and it's very clear from, for example, the impact assessment that accompanied the bill, that the desire is to protect freedom of speech in all its contexts, and very specifically in the journalistic context, as we'll see when we look at Clause 21 in a moment. And the aim is to secure increased weight to the importance of free speech by decision makers across the board, because obviously Clause 4 would catch circumstances where the courts are assessing whether another decision maker has made appropriate consideration of freedom of speech. In effect, Clause 4, taken together with Clause 22, restate and augment Section 12 of the Human Rights Act 1998. It restates because it includes, as we'll see in a moment, the provisions on relief and what the court should do when they're considering granting relief, which might infringe freedom of speech or Article 10 more widely. And it augments in that this Clause 4 takes away the specific framing of the granting of relief and puts freedom of speech and giving great weight to it, rather than having particular regard for it, at the front and centre of all decisions where this article and right might be engaged. So this is a significant augmentation on the existing position. There are, recognising that obviously Article 10 is a qualified right, various exceptions to Clause 4 set out in 4.3, and they very closely mirror the language in Article 10.2. So the great weight requirement wouldn't apply in criminal proceedings, or when considering the compatibility of legislation creating criminal offences. It wouldn't apply in cases relating to immigration and citizenship, which Miranda is probably very unsurprised about, and it wouldn't apply in cases dealing with national security. It also wouldn't apply to breach of confidence claims, but only very specific ones. And that is where the obligation of confidence arises under an agreement with any person or as a result of a professional relationship. Now, anyone who does breach of confidence claims in the audience will know that there is a category of cases where breach of confidence can arise even if there isn't an agreement or a pre-existing relationship. And that was established, for example, in the case of Mosley, which I've mentioned on the slides. Now, in the impact assessment, it very clearly states that the government doesn't like this extension of breach of confidence. And that is why in framing 3B, the exemption under clause 4, they have very clearly excluded this scenario. So in those cases, the freedom of speech great weight requirement would continue to apply, with the aim, no doubt, that those cases will be much harder for the person alleging breach of confidence to win, thereby fulfilling the government's policy aim to sort of close that avenue of cases down. Clause 4 isn't freestanding, even within the Bill of Rights as drafted. It's very clearly incorporated into the interpretation process that this bill is seeking to set up in terms of convention rights more generally. And this is secured in clause 3.2c, that the courts determining questions arising in connection with convention rights must comply with clause 4, which is, as we've discussed, the requirement to give great weight to the importance of protecting freedom of speech. Now, this is very significant because whilst clause 3 in general, and especially clause 3.3a, is seeking to allow domestic courts to adopt a much more restrictive interpretation of convention rights than Strasbourg might, there is a carve out of that for the freedom of speech. So it's very clearly stated in 3.4 that if you need to allow more expansive interpretation of convention rights in order to comply with clause 4, so giving the great weight to freedom of speech, you can do that. So we have a narrowing of interpretation unless freedom of speech is engaged. And that is a very interesting carve out given the general trend of the drafting of this bill in the narrowing direction. And I've quoted here from the memorandum that accompanied the bill, illustrating that intention. So the intention that this will lead to a more restrictive application of rights, and that the greater weight to be given to the importance of protecting freedom of speech will permit greater interference with other qualified rights if this bill was to be brought about. There is some reassurance in the memorandum that although there is going to be an expansion of protection to be afforded to freedom of speech, other rights won't be extinguished. The balance will just shift. It's very clear from the material accompanying the bill that the situation that the ministers and people drafting this legislation or future legislation have focused on is Article 10 versus Article 8 publication injunction cases. So where a party, a claimant, is relying on their Article 8 rights to prevent publication or to prevent further publication of material, and where the defendant cites their Article 10 rights in an attempt to resist that injunctive relief. Very interestingly, the accompanying material includes this table. It's in the impact assessment of the number of privacy injunction proceedings from 2015 to 2021, showing not really a pattern of growth, which is what they appear to be trying to suggest, but a peak around 2019 of 14 cases, which in the context of litigation in this country is not particularly significant. But their point that they make in the accompanying material is that these are only the cases which have got to court, and their concern is with the sort of shadow world of threatened claims which might have been used by claimants to prevent publication, and that never comes to the scrutiny of the court and therefore of the public. And a very strong focus in the accompanying material to sort of justify that and focus that concern is on the increase in strategic lawsuits against public participation, commonly known as SLAPs. And attendees who are at all involved with defamation will know that there was a call for evidence by the Ministry of Justice in March 2022, which closed a couple of months ago, looking at the impact of slaps. And effectively what these are, I've quoted what the Ministry of Justice describes them as in italics there, to show their attitude towards it, is effectively where defamation claims, data protection breach claims, and privacy law claims are brought by powerful entities, so individuals or corporations, to prevent academic publications, journalistic publications, and it's suggested in the accompanying material actually parliamentary affairs being carried out. So there's reference to claims being intimated against parliamentary clerks. And effectively that what this is the use of Article 8 by powerful interest groups to suppress public debate and public scrutiny of their conduct in various areas. And this freedom of speech amendment is one sort of front in the fight of the government against slaps. It's made very clear in the accompanying material to the bill that this is only one part to say, and that there are other statutory reforms coming, although based on what Richard said, how many of them come depends on the fate of Mr. Raab, because this is very much his baby, the focus on slaps. What do slaps actually look like? Because they are more well known overseas, I think. Particularly, there's a very sad Malta case of a journalist who was effectively driven into the ground and prior to being assassinated by, I think, over about 15 what are classified as slaps. But in this country, we have started to see recent examples in relation to Russian oligarchs. So I've got two on the screen here. So the Catherine Belton case. So that was around her book called Putin's People, which looked at the connections between Putin and various oligarchs such as Abramovich. And then the Burgess case, which is another FT contributor whose book Kleptopia was about dirty money. And that was the subject of a claim which has actually been dismissed, was dismissed in March 2022 on preliminary issue stage. The Putin's People case settled, but those are two examples of slaps which are identified by the media as an example of this problem, and no doubt would be relied upon by the government to support the need to strengthen Article 10 and weaken Article 8 proportionately. And the overall aim is very clearly to reduce the availability of the privacy injunction, anti-publication injunction as a weapon by these private interest groups. I have to say that there's very little consideration in the impact assessment of the change that there would be in free speech debates that are more popularly covered in the media, so deplatforming in universities. There's some acknowledgement that this would have an impact on individuals trying to put forward their Article 8 rights against people whose speech is offensive, etc., or to otherwise protect their Article 8 rights. But there's very little discussion of it beyond that. The focus is very much on slaps, which are a different category of case altogether. So said at the beginning, Clause 4 and Clause 22 are a sort of a double act because they represent a restatement and augmentation of Section 12 of the Human Rights Act. So turning to Clause 22, this is limiting the court's power to grant relief in circumstances where that relief might impact on Article 10 rights. So in this case, we're not talking about freedom of speech. Just lost my slide, but let's see if I can get back to it. Okay. In the case of Clause 22, we're not just talking about freedom of speech, we're actually talking about all of Article 10. So that is a continuation of the current position under Section 12. So this clause continues the imposition of the limit on the granting of any relief. So that's any remedy or order which might affect the exercise of Article 10 rights. And the limits are that no such relief is to be granted in the absence of the respondent. So that's this respondent personally or their legal representatives, unless the court is satisfied that the applicant has taken all practicable steps to notify the respondent, or that there are exceptional and compelling reasons why the respondent should not be notified. And I was trying deliberately to put emphasis on exceptional and compelling reasons for a reason which we'll come on to in a moment. And further, that no relief restraining pretrial publication will be granted unless the court is satisfied that the applicant is likely to establish publication should not be allowed at the substantive hearing. So this is where we come on to my deliberate emphasis. The key changes from section 12, the parts that are preserved in clause 22 are: we now have exceptional and compelling reasons to proceed to grant relief in the absence of a respondent where all practical steps to notify have not been taken. Now, this is very significant because obviously the reason that you don't notify people in privacy cases is that they might proceed to leak the information or publish it in such a way as to render the substantive claim pointless, and, you know, prevent you from protecting your Article 8 rights via seeking the intervention of the court. And in this case, it has to be shown by that claimant that their decision not to notify is justified by exceptional and compelling reasons, which they will have to evidence to the court. So that is obviously lifting up the bar that a claimant would have to clear to get the relief they want. Another change is that section 12.4 of the Human Rights Act is gone. It's not included in clause 22, which otherwise follows the text of section 12 quite closely. Now, section 12.4 was the provision that the court must have particular regard to the importance of Article 10 and whether proceedings relate to material which a respondent claims or which appears to the court to be journalistic, literary or artistic. They have to have particular regard to the extent to which the material has already been published or is about to become available to the public, or it would be in the public interest for it to be published, and any relevant privacy code. Now, the first part of 12.4, particular regard to the importance of Article 10, has effectively been lifted out and put front and centre in clause 4. So that's not surprising that that's not now in clause 22 as well. What is surprising, given that the government's aim is to strengthen, especially protection of journalistic freedom of speech, is that they've got rid of the second part, which is the specific practical factors to which the courts have always had regard in deciding whether publication of such material should be allowed. Now, it's unclear, well, it's clear that this omission has been deliberate because it's said in the accompanying material, but it's not clear what the impact of that omission would be. It's possible that the courts would still consider those elements when they're looking at the balancing exercise between Article 8 and Article 10. And certainly in the case that Richard mentioned that I did, the Kent County Council case, that was something that the court did consider without any reference to section 12.4, was how much of this information is already in the public domain. But the fact that that statutory footing for that will be taken away will mean that the courts will have to consider whether there is a basis for those considerations outside of the statute if the bill is passed as it currently is. Maybe that this is a mistake and that the government haven't thought particularly carefully about getting rid of the second part of 12.4. So we shall have to see. Another interesting omission from the text, which, apologies, isn't on my slide, is that section 12.5 says that court includes a tribunal. Now, clause 22 doesn't have any definition of court, so it's not clear whether it's intended that this limit would just be courts and not tribunals, as is the position under section 12 of the Human Rights Act. So it will be interesting to see what direction that goes in and whether there is an amendment on that point. Moving on then to disclosure of journalistic sources, that's clause 21. This provides that the court may not require disclosure of journalistic sources unless it's satisfied that disclosure is necessary in the interest of justice or national security or for the prevention of crime and disorder, and there are exceptional and compelling reasons why it's in the public interest for the disclosure to be made. And the same test would apply in deciding whether someone will be guilty of contempt of court for refusing to disclose journalistic sources. In determining whether there are exceptional and compelling reasons, the court must give great weight to the public interest that exists in protecting journalistic sources, including the fact that their protection supports the convention rights set out in Article 10 of the Convention. So again, here we're dealing with Article 10 in its full state, not just with the freedom of speech element. And interestingly, as opposed to clause 22, where this isn't stated, this limit will apply to anybody exercising the judicial power of the state, so not just courts. The definition of journalistic source is a person who supplies information to another person intending it to be used for purposes of journalism or knowing that it is likely to be so used. So this is intended to be a strengthened equivalent of section 10 of the Contempt of Court Act 1981, which effectively does the same, imposes the same limitations with the changes that without the changes that I've identified on the slide. So that will continue, section 10 will continue to exist separately, but clause 21 would apply to journalistic sources in particular. So as I said, expressly applies to journalistic sources. There's also a new definition of what those sources are, which wasn't there before in the statute. Interestingly, it's not confined to publication for which the person is responsible. So section 10 related to sources of information contained in a publication for which the person in particular was responsible. So that requirement has been removed. There's also now an exceptional and compelling reasons in the public interest requirement. So in previously, the exception to disclosing journalistic sources was that disclosure was necessary in the interest of justice or national security or for the prevention of crime or disorder. So here we have an exceptional and compelling reasons in the public interest test. So the threshold again is being lifted up for people seeking such disclosure. And there's an express requirement now to give great weight to public interest in protecting journalistic sources in line with Article 10, which whilst it might have been part of the exercise under Section 10, wasn't stated explicitly anywhere. And as I mentioned, it applies to anybody exercising judicial powers of the state. Before I hand over to Luke, I think in closing, it's very clear what the government's agenda is in relation to these three changes, clauses 4, 22 and 21. I think they've got some tweaking to do if they really want to achieve their full purpose, in particular in relation to protecting journalistic source material. But I would agree with Richard's comments that there appears to be consensus politically within the Conservative Party that these are the sorts of changes that they want, and that this is unlikely to be impacted by the current political shenanigans going on, although that might be famous last words from me. So without further ado, I'll now hand over to Luke, who will talk about overseas military operations.
Thank you very much, Katharine, and good afternoon, everyone. I'm just going to make sure I have control of the screen, which I do, and I can proceed to the final topic in this series, which I'm afraid to say is considerably more niche than the two talks we've just heard. And that is about the application of convention rights under the Bill of Rights Bill, assuming it becomes an act in due course, to overseas military operations. I'm going to break this talk down into 5 subjects. We'll begin by having a look, since this is a niche topic that not everyone will be aware of the background to the extraterritorial application of convention rights as it's been established through the Strasbourg jurisprudence so far. We'll then have a look at 2 cases in particular. They're about 10 years old in each case now, which have been identified by the government as setting up the mischief at which the Bill of Rights is aimed. We'll have a look at what the government's intentions are, as set out in consultation documents and so on. We'll look at the provisions of the Bill of Rights itself as they bear on this question. And we'll conclude with a few thoughts of my own on some of the challenges and risks which exist around the proposals which have been put forward. Beginning then with the general position which applied for a considerable number of decades, actually up to the mid-noughties, as to the application of the convention extraterritorially. And the general position, the starting point, was that the convention didn't apply beyond the territorial boundaries of the state signatories to it. 2 cases which exemplify that limitation are the Suring case and the Bankovich case. What they both say, pretty clear terms, is that there is no general obligation on a state signatory to the convention to try to impose through its own actions convention standards on other countries. That essentially is the reason why the court held in Suring, for instance, that there was no extraterritorial application. You know, it would involve an interference in bilateral state relationships, which the convention was never designed to do. Bankovich extended things a little in that it identified the possibility of an exceptional circumstance or exceptional circumstances wherein acts which were beyond the territory of a state could nevertheless be treated as being within that state's jurisdiction for the purposes of the convention. But it's very clear in Bankovic that these were intended to be very narrow range of circumstances. It was the idea was that it should only be truly exceptional when a state would find itself held accountable under the convention for things that it did overseas. Things changed somewhat in the context of armed forces activities in the two cases that I'm going to turn to now. The first is the Al-Skeini case. This was a claim that was brought against the UK government by the relatives of a number of Iraqi citizens who were shot and killed by British soldiers during the Iraq War. The case proceeded all the way to the House of Lords in the domestic courts, and the House essentially held that the convention didn't extend, or at least not in the way that was claimed by the claimants, to the activities of the armed forces personnel in question. The claimants took their case to the European Court, and the European Court held that effectively, well, it held that the soldiers' actions were within the scope of the convention. Helpfully, the court set out three sets of circumstances in which a state's extraterritorial actions could be within the convention. The first was where a state's agents are exercising authority and control over others, so that the focus is very much on the control of how a person is living or what the person is doing. The second is where a state is invited or, with the acquiescence of another country, undertakes public functions which ordinarily would be done by the government of that state within that state's territory. One thinks one can imagine a situation, for instance, in which a country which was adjacent to one which was subject to a war zone might invite one of the invading parties to participate in police actions on either side of the border or something like that. In that situation, what would be happening would be that the occupying state, the invading state, would be carrying out the sort of function a government would do within another location. And in that situation, that location for those functions is regarded as being within the jurisdiction of the state party. And the third is where effective control over a territory outside of the normal borders of the country has been achieved via military action. And Al-Skeini was very clear that it doesn't matter for these purposes whether the military action in question is lawful or unlawful in the international law sense. The mere fact of effective control through military action is sufficient to engage the convention, to bring Article 1 into play, and for the actions of the country to be regarded as within jurisdiction. So, as I indicated, the result of Al-Skeini for these purposes was that there was a jurisdictional link to Iraq. Effectively, the presence of the soldiers created a jurisdictional connection such that for Article 1 purposes, the victims of the shootings were able to claim convention rights via their relatives. How that manifested within domestic law, it occurs most cleanly and most easily to explain, I think, within the Smith and MOD case, which is from 2004. This is a case some of you may remember, the Snatch Land Rovers issue. It was a claim both under Article 2 of the Convention and in common law negligence, brought by a number of relatives of UK soldiers who had died because of alleged deficiencies, both in the equipment selected for their patrols and in the manner in which patrols in Iraq were actually undertaken. The equipment in question was the now much maligned Snatch Land Rover. The Supreme Court held by majority that Al-Skeini had established, essentially contrary to Bankovic, that the hurdle for exceptional circumstances wasn't a particularly high one. In other words, it doesn't have to be that exceptional to be exceptional for these purposes. The jurisprudence had moved on and evolved in accordance with the living instrument doctrine since the time of Bankovic, such that Article 2 of the Convention was capable of being engaged in respect of members of the armed forces who were operating abroad in terms of what they were doing in theatre overseas. A point that isn't on the slide, but which I found quite interesting, was one of Lord Hope's points, which was that under Al-Skeini, the jurisdictional link from the UK to Iraq occurred because the UK was held via its agents, its soldiers, to be exercising effective control in Iraq. It must necessarily follow, Lord Hope said, and I think it's clearly right, that if control of Iraqi citizens is manifested by the UK through its soldiers, then by definition, the UK is exercising control over its soldiers as well, in the relevant sense to engage the jurisdictional connection and bring the convention into play. So that's the context in which the Bill of Rights, as it deals with this issue, has arisen. That's the, as the government will put it, the mischief that is sought to be addressed by the relevant parts of the new Bill of Rights. The consultation on the Bill of Rights has several pages on this issue, and it identifies 4 key themes which has led the government to want to intervene and to alter the position that's arisen under Smith and Al-Skeini and cases like them. The first is the issue of uncertainty. The consultation stresses that what it describes as the extension of human rights law into the realm of armed conflict has created uncertainty both legally, it's unclear in any given case quite whether or not convention rights will be engaged, and also operationally. The, one might say, spectre of a human rights action is something which, according to the government, will be in the minds of those making operational decisions in the context of conflict. And that uncertainty is regarded by the government as a mischief that needs to be reformed. Secondly, the government has pointed to the travaux préparatoires of the convention and has drawn from the travaux the idea that the convention was never designed to regulate conflict. And the government's view is that it is ill-adapted for that purpose. The convention is essentially targeted at the activities of a state within its ordinary jurisdictional area and in its ordinary civil dealings with its citizens and with others who are present in its area, not designed to regulate activities in conflict zones which are undertaken by the armed forces. Third related point is that the convention, according to the government, is being effectively superimposed onto the armed forces on top of a series of international law obligations and instruments, of which the Geneva Convention is perhaps the most famous, which are specifically designed to regulate conflict zones. The Geneva Convention, being drafted to apply in the context of war, takes into account, according to the government, the particular imperatives and vicissitudes which arise in that context, which simply don't exist in anything like the same way in the course of ordinary civilian life. And the fourth element the government identifies is the cost and morale issues which have arisen from cases like Al-Skeini and cases like Smith. It's suggested that human rights litigation is having an adverse morale implication for members of the armed forces, not to mention the very, very significant costs in legal fees and general litigation costs which arise where these matters have to be litigated in court. What then does the Bill of Rights propose to do about all of this? How's the government planning to address these issues? The critical part of the bill for these purposes is Clause 14. And Clause 14 introduces a number of restrictions on Section 13 of the bill, as it'll become, if it becomes law. Section 13, you'll have heard about in previous talks, is the right to bring proceedings for breach of convention rights, which is to be introduced by the Bill of Rights. The way that Clause 14 is structured is that it sets out a series of specified disapplications of the right to bring proceedings. It's essentially one big series of ouster provisions. The first one, which you find in Clause 14.1, disapplies the right to bring a human rights claim or to claim the application of the convention full stop in respect of an act or proposed act done or proposed to be done outside of the UK by a public authority, in practice the armed forces, in the course of overseas military operations. Paradigm example of the sort of thing this is aimed at are tactical operational decisions taken by commanding officers of the armed forces in theatre. You know, if a patrol comes under fire and its commanding officer tells it to go left rather than go right, that is no longer something which can be subject to human rights convention type scrutiny. The second exclusion, which we find in clause 14.2, relates to activities which occur in the UK or decisions taken in the UK, but the effect of which will be felt overseas within a conflict zone. The necessity of this provision seems to me to be twofold. One is that high-level strategic decisions about the conduct of war will, in many cases, be taken in London rather than in the conflict zone itself. And the provision is designed to ensure that decisions taken in London, which manifest strategically on the battlefield, are no longer going to be subject to human rights claims. A second limb of this, which is relevant very much to the nature of modern technologically focused warfare, is the fact that in many cases, increasingly, things like drones, as I understand it, can be operated from anywhere. Yeah, it may well be that the controls of a drone exercising a strike overseas are being operated by a soldier pilot who is nowhere near that conflict zone and in a location that is firmly within the UK's jurisdiction on conventional principles. In that sort of situation, clause 14.2 disapplies convention rights as well. The third provision prevents persons related to persons whose rights have been infringed from bringing claims by virtue of the relationship. Very clearly aimed, it seems to me, at something like the Smith situation, where it was the relatives of deceased soldiers who were bringing claims. And finally, clause 14.4 disapplies the convention for investigations and inquiries into any matter where clause 14.1 or 14.2 has brought the disapplication into effect. So this is very clearly intended to prevent the Article 2 investigative right from being engaged in respect of decisions about the conduct of conflict overseas. That again is made clear by the explanatory notes to the bill. Clause 14 makes clear that it doesn't prevent convention rights from being relied on in criminal proceedings. It's targeted purely at specific civil human rights claims under clause 13. And clause 14 concludes with a definition of overseas military operations. It includes things like peacekeeping operations, counter-terrorism operations, and operations to deal with civil unrest and serious public disorder. The trigger for those kind of operations qualifying as overseas military operations for the purposes of the bill is that the armed forces personnel come under or face the threat of attack or violent resistance. Now, there's a potential grey area here in that it's not specified in the bill, and it will need, seems to me, to be resolved by litigation in due course, whether or not it is the conflict as a whole which is assessed for these purposes, or the specific operational part of the context in which the claim arises. One can imagine, for instance, an accident happening on a routine patrol in which the soldiers taking part in the patrol were not attacked. There was no intelligence that any attack was imminent, and the incident in question occurred not in any way in the face of the enemy. In that situation, would the patrol qualify as an overseas military operation for these purposes? It's unclear at the moment. That's the sort of thing, as I say, that's going to have to be resolved by litigation. One thing the government has made clear in the human rights memorandum which accompanies the bill, I think it was the memorandum, it may have been the explanatory notes, but in one of the associated documents, it's made clear that overseas training exercises, for instance, are not within the scope of clause 14, so that a death which occurs in the course of a training exercise can be the subject of a human rights claim in exactly the way that's the case now. A final point for linguistic purists out there is that the term military in overseas military operations is in fact inapt. It's not the right term to have used. It's very clear from the definitions section for clause 14 that this applies to the armed forces as a whole. Naval operations and air force operations are also within scope, not just the army. So the word military shouldn't be anywhere near that definition, but I think we know what they mean. Now, one of the things which will be obvious, I hope, from looking at Al-Skeini and Smith and then the provisions, is that clause 14 is very obviously, deliberately and explicitly intended to pull back from convention rights as they've been established by the court. It will unquestionably have the effect, if it were applied as it stands and without any replacement, of reducing convention rights as established in Al-Skeini, for instance. How then can it be that the Lord Chancellor has been able to sign a declaration which asserts that the Bill of Rights, and in particular clause 14 of the Bill of Rights, is consistent with the convention? The answer the government tells us is in clause 39. Clause 39 is the commencement provision for the bill. And what that tells us is that the Secretary of State may not bring clause 14 into force unless he or she is satisfied, whether on the basis of a provision in another act or otherwise, that doing so is consistent with convention obligations. Now, I can't think of a similar or comparable commencement provision where the power to commence is subject to this kind of control and this kind of exercise of judgment by a Secretary of State. The intended trigger, which the government has in mind as lying behind clause 39.3, forgive me, is this: the government says it intends to introduce what it calls alternative remedies to cover these circumstances. Now, what those remedies are, what they might be, isn't specified anywhere. The explanatory notes tell us that the Secretary of State may require either the introduction of alternative remedies within subsequent legislation, or, and I think this is quite telling, the revision of extraterritorial jurisdiction under the convention. So it may be that what the government's hope is that in due course, the European Court revisits this issue and concludes, in fact, that Al-Skeini was wrongly decided and that the extension of the jurisdiction of the convention into war zones and conflict theatres ought to be scaled back. If that hope is not realised, then it seems the government's going to introduce some alternative yet to be defined, which it hopes will do the job of ensuring convention compliance as a matter of international law. It seems to me that it is that very issue, the compliance of the alternative remedy with the convention as a matter of international law, on which the success or failure of this whole policy imperative is going to hang. I think it's a very tricky exercise the government has to undertake here, because on the one hand, it's going to need to introduce something which is sufficiently robust, sufficiently enforceable, sufficiently investigative in the right way, and with sufficient involvement by those who allege infringements to be compatible with what Strasbourg has said in the past about how convention rights are complied with by these sorts of provisions. On the other hand, for this exercise to be worth doing at all, it's got to address the mischiefs which the government identified in the first place. If the alternative remedy that's brought in is exactly as damaging to morale in the armed forces as current litigation is, for instance, or it is just as costly or introduces the same levels of uncertainty, then frankly, why bother? It'll simply be window dressing. It seems to me that there is a pretty narrow window within which the mischief can be addressed and Strasbourg can be satisfied. It may be that that window is so narrow that it actually isn't there at all. Maybe that this simply can't be achieved. And I wouldn't be overly surprised if whatever comes forward ends up being challenged in Strasbourg, perhaps successfully, if the policy imperative is to be achieved. Now, I've no idea and I haven't seen anywhere any indication of the sort of alternative remedy the government has in mind. An obvious way that it might wish to proceed, and which is proceeded with in similar contexts elsewhere, is with an ombudsman type setup, where rather than having adversarial court proceedings to resolve these issues, they're dealt with inquisitorially by an investigation that could be very much cheaper. Now, an ombudsman would, in all likelihood, reduce the cost of this kind of litigation. Would it reduce the uncertainty? Unclear. Would it reduce the adverse impact on morale as the government's identified it? Again, unclear. For an ombudsman to satisfy Strasbourg, its decisions would have to be enforceable by the courts. Would that remove the kind of litigation threat that the government's concerned about? Again, unlikely to be the case. And I can't help but draw comparisons with other ombudsman situations I'm aware of, where real difficulties run into when ombudsmen are charged with effectively carrying out jurisdictional oversight of areas which are very technical rather than which are administrative. One thinks of some of the challenges the public health ombudsman gets into with clinical decisions, or that the local government ombudsman gets into when it's asked to oversee the substance of a planning decision. The ombudsman concept is far better suited to things like maladministration or customer service failures than it is with addressing the human rights compliance of a tactical battlefield decision. So if an ombudsman is the option that's chosen by the government, it seems to me that there are going to be challenges in making that work in practice, even if it can satisfy the twin imperatives I've identified earlier. If the Bill of Rights proceeds and if Clause 14 becomes law, it'll be very interesting indeed to see what the government does about this and how in due course Strasbourg reacts. Thank you very much, everyone, for listening. I hope that was interesting. And that brings my talk and indeed this session to a conclusion. So I'll pass you back to Richard for the Q&A. Thanks very much.
Thank you, Luke. Thank you, Miranda. Thank you, Katharine. We now move to the last part of the talk. Can I first, before we do that, just traditionally express the thanks of my thanks, and I'm sure the thanks of the audience, to all three speakers for the fascinating and extremely clear talk on a rather complicated set of provisions. So thanks again. In a conventional pre-Zoom world, I would ask those who are still online to show their appreciation in the traditional way, but we can't do that. At least I don't think we can do that, but thanks very much indeed. Now we do move on to the question and answer session. Actually, aren't very many questions have come through from the audience, so I just want just to ask a couple of them of my own, and we'll see where we've got to at the end of that. If anyone out there has got a question which they're burning to ask, you've got to do it now, because this is the moment will have passed almost straight away. But can I first of all just ask Miranda a couple of questions about Clause 8? First of all, you point out a striking feature of Clause 8, that it's not dealing with individual decisions, it's dealing with what can or can't be in a legislative provision, which presumably includes statutory instruments, but probably not the immigration, as I understand it, but that may be a matter for debate. Can you just say a bit more about what the relationship is between the requirements of Clause 8 and its relationship and its relationship to other legislative provisions and individual decision making? In other words, what sort of legislative provision have we got in mind? Is it something that mandates deportations if the sentence of imprisonment is longer than a year or longer than 6 months or whatever? What sort of legislative provision are we talking about? Do you know? Is it possible to tell? How does that work? That's a really
excellent question. The legislation is very broad, and I would anticipate that it would essentially refer to any legislative provisions, possibly including the immigration rules, that set out rules under which individuals can be deported, or perhaps even that concern the circumstances in which deportation might be carried out. I think the meat of that provision is clearly targeting substantive rules about the circumstances in which individuals can be removed when they have family in the UK or establish private life in the UK. But I could imagine it growing more broadly. We, of course, talked about Lord Wilson's judgment in Chiari and Benjamin and the Article 8 procedural protections there. I think that you can see rules around things like default first, appeal later, or, for instance, the Rwanda scheme. Rwanda, of course, isn't a deportation provision, but if that was applied to individuals who are deemed by statute to be foreign criminals, then arguments around impact on family life or Article 8 procedural fairness about the possibility of being brought back could potentially engage Clause 8. So, of course, the proof will be in the pudding, but currently it's deportation provisions, as the bill refers to them, are ignored.
In other words, it's envisaging that the other legislative provision will produce a mandatory result which can't be interfered with because it's protected by 8.2. So in Kiri and Bindlos, which I know well, it will be default first, appeal later. That's a mandatory requirement. You can't say it's ultra vires or overridden by what would now be Section 6 of the HRA, because 8.2 prevents you. That's the way it works.
Spot on, absolutely.
We don't have a situation in which the individual court has to apply an extreme harm test in an individual case and then come up against Strasbourg decisions later which say extreme harm isn't the test, or
so I presume that that's going to be the effect of this. So what the government has said is that this will allow them to pass laws that will make it harder for foreign criminals to resist deportation on human rights grounds. So I think the idea is that this is a gateway, and it's a gateway to new legislative provisions that will require courts in assessing Article 8 default claims to apply some extremely exacting threshold. I would presume be manifest an extreme harm threshold.
Okay, let's move off deportation. We have actually got a question for Luke about whether he wants to say or can say anything more about the position in relation to amnesties in Northern Ireland. I don't know whether you want to rise to that challenge, Luke, or not.
Well, that's an extremely interesting and very controversial set of provisions which actually aren't contained in the Bill of Rights. The Bill of Rights provisions we've been looking at today, Clause 14, are specifically concerned with the extraterritorial application of the convention. So it's about things which happen outside the UK. Northern Ireland, of course, is very much a part of the UK. And the proposals around immunity from prosecution, the creation of an independent commissioner and so on, are dealt with in a specific, discrete and separate piece of legislation. It's called the Northern Ireland Troubles Legacy and Reconciliation Bill. It's passed through the Commons. It's currently before the House of Lords. And I'm afraid that is very much a topic in its own right that goes quite a long way beyond the Bill of Rights provisions we've been concerned with today. So if that's something about which there is interest, I'm very happy to discuss it separately and offline. But I think it would go beyond too far beyond the scope of what we're talking about today to go into it in any more detail, Richard.
I think you will find when you actually look at the Q&As when you've got a moment, there's another question on the same area about historic potential breaches of human rights with long adjourned coroner's inquest. But perhaps you could have a look at that and possibly come back if it looks sensible offline afterwards. Can I just ask Katharine, perhaps just one last question for now, unless I hope there are, unless someone else comes through on the Q&A session. Katharine, do you want to say anything more about the concept of bodies exercising judicial power of the court, of the state, is the phrase? What sort of bodies are we talking about?
Yes, so I was very interested when I first read the bill to see this phrase, because it wasn't one that I was instantly familiar with. I've not come across it before, because obviously in human rights context, what you're always asking is, are we dealing with a public body or not, or a body exercising public functions? So body exercising judicial power of the state is a contempt law concept, and it comes from, originally a decision of Lord Scarman in a BBC case from 1981, which was about whether a local valuation tribunal, whether its proceedings could be reported on while an appeal was still outstanding. And effectively the issue was, does contempt apply to all bodies exercising judicial power or only some? And this is where it gets complicated, because Lord Scarman held that although a local valuation tribunal is a tribunal and it looks like it is exercising judicial power, it's only an administrative court, it's not a judicial court. So in his decision, which wasn't appealed in that BBC case and hasn't been overturned since, a tribunal isn't actually a body exercising judicial power of the state. So it's unclear whether those drafting clause 21 have understood the complexity and the issues that are going to be thrown up by including this, and by effectively importing out of contempt law into human rights law this very specific concept, which, according to all the practitioner texts I've looked at, is incredibly ambiguous and effectively is decided on a case-by-case basis. And it will be very interesting to see if this bill was implemented as drafted, how this concept might develop, because it does appear to cut across public bodies, all public bodies being caught by human rights related considerations. So yeah, it's basically a very unclear and unsatisfactory legal position as far as I can tell, and this is bringing it into the foreground of human rights law from the back shelf of contempt law.
I've actually been asked to speculate on something completely, well, not completely different, related, but whether you have any thoughts about whether equity, domestic law of equity, will develop in order to fill any gaps left by the Bill of Rights interference with in this area.
So I'm assuming that that's a question about, would equity respond to the clause 4 provision that the great weight consideration wouldn't apply. I mean, it doesn't appear to me that what the government is trying to do is to get rid of the Moseley class of breach of confidence claims. It's just saying that in that case, you would need to consider freedom of speech and give great weight to it, whereas in others, you wouldn't. So in agreement cases and in professional relationship cases, because the government likes those classes of breach of confidence, you wouldn't have to give great weight. But this third class that it doesn't like, you would have to give great weight. And obviously the intention, as I said, is that you would weaken claims by the introduction of freedom of speech concept in cases where there isn't a relationship or agreement. I think that the courts are very inventive at using common law and equity to fill in statutory gaps where they feel they need to, in order for, I think, pragmatic decisions to be reached in the fields of breach of confidence. Because obviously the court in confidence cases is concerned with not importing duties of confidence in all situations, because that would just lead to a complete nightmare. So it is slightly outside the bounds of this discussion, but I think that the courts wouldn't be unwilling to use equity to plug the gaps if it's felt that this is effectively torpedoed the side of a certain class of breach of confidence claims. But again, it's going to be very interesting to see if the bill is put through into legislation as currently drafted, what the actual outcome of that is going to be. And the same with the point about 22 and the omission of 12.4, what the court's going to do about that, because that would be also the common law stepping in to basically take up the baton of the statutory considerations that have been stripped out by this bill.
Well, I think that's the end of the questions that we've been asked so far. And I would just like to repeat my thanks to the participants, to the speakers once again. Thank you very much indeed. To the audience for staying with us through on what is a nice sunny day. We can all possibly go out now, or we may find that some emails have come through which require attention, but never mind. So thanks again to all the speakers, and thanks to the audience. And that's the conclusion of the landmark series of webinars on the Bill of Rights. Thank you.